Idaho is one of the most landlord-friendly states in the country, and its approach to habitability reflects that. If you own rental property in Idaho, you'll find a regulatory environment that gives landlords significant flexibility, but still holds you to fundamental standards. Idaho's landlord-tenant law is found in Idaho Code Title 6, Chapter 3, specifically Sections 6-320 and 6-321, which outline landlord and tenant duties respectively. The framework is relatively concise compared to states with extensive landlord-tenant acts, but it covers the essential obligations. Under Sections 6 through 320, Idaho landlords must comply with all applicable building and housing codes that materially affect health and safety. You're required to maintain the roof, walls, and structural components in reasonable repair, keep plumbing facilities in reasonable working order, maintain the electrical systems serving the property, provide adequate heating facilities in reasonable working condition, provide running water and reasonable amounts of hot water, and maintain any appliances that are supplied as part of the rental. Notice the word reasonable appears frequently in Idaho's statute. That's intentional. Idaho's standard is reasonableness, not perfection. Courts evaluate whether the landlord acted reasonably under the circumstances, which gives landlords more breathing room than states that impose strict compliance standards. A minor plumbing drip might not rise to the level of a habitability violation in Idaho the way it might in a state with more exacting standards. Idaho's climate creates specific maintenance priorities. Northern Idaho and the mountainous regions experience harsh winters with heavy snowfall and freezing temperatures, making heating systems critical. The southern part of the state, particularly the Boise area and the Snake River Plain, deals with extreme summer heat where air conditioning becomes important. And across the state, the dry climate can cause unique issues like foundation settling and cracking that landlords need to monitor. When a habitability issue comes up, Idaho follows a notice and repair process. Under Section 6-320, the tenant must provide the landlord with written notice of the problem. The landlord then has 3 days to begin the repair for conditions that pose an imminent threat to health or safety. For non-emergency conditions, the landlord has a reasonable time. Courts generally look at the nature and complexity of the repair when determining what's reasonable. Here's something that sets Idaho apart. The state has a specific provision allowing the tenant to pursue the repair and deduct remedy. Under Section 6-324, if the landlord fails to make a repair after proper notice, the tenant can hire a licensed, bonded contractor to make the repair and deduct the actual cost from the next month's rent. However, the deduction cannot exceed 1 month's rent. The repair cannot be structural, and the tenant must have given proper written notice and allowed the required time for the landlord to act. This is a more structured repair and deduct process than what you'd find in many states. If the landlord's failure to maintain the property is material, Idaho tenants can also pursue lease termination. Under Section 6-322, the tenant can deliver written notice that if the condition is not remedied within 3 days, the rental agreement will terminate. If the landlord doesn't fix the problem within that window, the tenant can move out and is released from further obligation under the lease. Idaho tenants can also pursue damages in court for breach of the landlord's statutory duties. This includes rent abatement for the period during which the property was deficient, as well as actual damages for any losses resulting from the landlord's failure to maintain habitable conditions. One practical consideration for Idaho landlords: the state has experienced rapid population growth, particularly in the Boise metro area. This growth has put pressure on the rental market and increased scrutiny of rental housing conditions. Cities like Boise, Meridian, and Nampa have their own local building codes and inspection processes that supplement state law. As the state continues to grow, landlords should expect that code enforcement may become more active in areas that were previously lightly regulated. Idaho's anti-retaliation protections are found in Section 6-321. Landlords cannot retaliate against a tenant for making a good faith complaint about habitability to a government agency or for exercising any right provided by the landlord-tenant statute. The protection is straightforward and applies statewide. For the full guide to Idaho's habitability requirements, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for more state-by-state landlord guides.